Hi, bankruptcy attorney Brian Barboza here, and today I'm going to discuss will bankruptcy get rid of credit card debt? Before we get started, if bankruptcy is something you want to explore, you want to talk more about, please feel free to go to my website, barbozalaw.com, book an appointment to speak with me for free directly through the website. Okay, so will a bankruptcy get rid of credit card debt? So when you file a bankruptcy case, what you're ultimately doing is you are filing a petition and you're seeking an order from a federal judge, a federal bankruptcy judge, and that order is going to declare that you are discharged of your debts, at least the debts you can legally discharge in a bankruptcy case. And as a general rule, credit card debts will be discharged in a bankruptcy case. So yes, generally speaking, credit card debts are dischargeable in a bankruptcy. However, there are some exceptions to that general rule. So let's go over a couple of those exceptions. So, number one, if you were using your credit cards either excessively or for luxury goods or luxury services or cash advances within the 90-day window of time leading up to your bankruptcy case filing, then in that instance, the credit card company could send an attorney to bankruptcy court and they would file an action against you called a non-dischargeability action, seeking an order that those charges are not to be discharged in a bankruptcy case because there's a legal presumption you knew you were going to file bankruptcy and you had no intention of repaying those charges. And the judge could also tack on that credit card company's attorney's fees. So that is one exception that from time to time does happen. Now, they could also bring a similar action for charges that were outside of that 90-day window, but it's much more tenuous, it's much more difficult because they would have to actually prove your intent of not repaying those charges. So one exception is non-dischargeability action for excessive charges of credit card abuse, luxury services, luxury goods, cash advances within that 90-day window of time before you filed your bankruptcy case. Another exception would be for fraud. So let's just say, and this is just an example, you filled out your credit card application, you said you made $200,000 a year of annual income, you only made $20,000 a year of annual income, but for that material fraudulent misrepresentation, that credit card company would never have given you a credit card, but they did because they relied on that statement, and then you charged that credit card up and then you filed bankruptcy. Well, they could come into court and they could seek an order that you cannot discharge that credit card debt because it was incurred through fraud. Makes sense, right? So that does happen from time to time. Don't see it often, but for serious fraud like that, a credit card company might want to send an attorney to get an order that you cannot discharge that credit card debt. So those are a couple examples. There are a few others, but those are kind of the primary ones. And if bankruptcy is something you want to talk more about or you want to explore, please feel free to give me a call or go to my website, barbozalaw.com, book an appointment to speak with me for free directly through the website. As always, I hope this was helpful. Hope you got something out of it and have a good rest of your day. Take care. Bye.